Our next speaker is David Whitney. David graduated from Rutgers University as a Henry Rutgers Honors Scholar with honors in history, received a master's degree from Denver Seminary, and he is a pastor of Cornerstone Evangelical Free Church in Pasadena, Maryland. For 30 years, he's actively defended the family and preborn on the street as well as in the state legislature. For the past 10 years, he's been teaching with the Institute on the Constitution. He and his lovely wife, a lovely, talented wife and daughters, reside in Annapolis, Maryland, and you have a mic.
Thank you so much, Jody. I appreciate it. And thank you, Senator Stallings, for being with us, and thank you all of you who have joined. I want to just make the clear point that constitutionally speaking, what we're talking about is completely legitimate. In other words, the powers we, the people, have granted to the federal and state government in our constitutions, this is supportive of. By the way, if you're interested, my email's there if you'd like a copy of these particular notes. To abolish abortion would begin with the Fifth Amendment to our Constitution that says no person shall be, and then there's a long section in there of protections, but let me just go to the latter part. No person shall be deprived of life, liberty, or property without due process of law. This is written into our law, and it says no person. Now, like Michael said the word all. I think the word no is very clear. We know what this means. Now, when we look at the definition of person that would have been understood by our founders, the source we go to is Webster's 1828 dictionary, the first American dictionary. This was one of the founders, and in that era they would have understood what these terms mean, for example, there in the Fifth Amendment. So a person is an individual human being consisting of body and soul. We apply the word to living beings only possessed of a rational nature. The body, when dead, is not called a person, and it is applied alike to man, woman, or child. So clearly, our founders, when they used the word person in the Fifth Amendment, this is what they were understanding. So let's all the 14th Amendment, because this speaks of all persons as well. And again, we'll skip a section that doesn't apply, but notice what it says as well. Nor shall any state, that'd be the state of Maryland, deprive any person of life, liberty, or property without due process of law. There's that phrase again from the Fifth Amendment. Nor deny any person within its jurisdiction the equal protection of the laws. Again, any person, of course, would include the unborn human being. So clearly, we have these two things that are being stated. And so, for a person to be deprived of their life as a human being requires, according to the law, they must be placed on trial before a jury of their peers and determined by that jury of their peers that they are guilty. This is the only way, according to due process of law, someone can be deprived, a person can be deprived of life according to our Constitution. Therefore, any so-called law which says that some human beings may be deprived of life without this due process, that cannot actually be law, as it violates the supreme law of our land, the U.S. Constitution, as well as we're going to see in a moment. It also violates the supreme law of our state, that is the Constitution of the state of Maryland. Now, each elected official, before they begin to function in their office, they take an oath of office, and that oath is given to us so that they are swearing before Almighty God to do a certain set of things, which is to uphold the U.S. Constitution as well as to uphold the Maryland Constitution. So they're making a promise to Almighty God to do the following. Look at the oath. I, blank, that would be the person's name, do swear or affirm, as the case may be, that I will support the Constitution of the United States and that I will be faithful and bear true allegiance to the state of Maryland and support the Constitution and laws thereof, that is of Maryland. And I will, to the best of my skill, judgment, diligently, and faithfully, without partiality or prejudice, execute my office of blank according to the Constitution and laws of this state. And if a governor, senator, member of the House of Delegates, or judge, that I will not directly or indirectly receive the profits of any part of the profits from any other office during the term of office, my acting as, and again, fill in the blank. So that's the promise that they make. So let's consider what they're making a promise to. One element is our Maryland Constitution. The Declaration of Rights, Article 2, makes it very clear. They're promising that the Constitution of the United States and the laws made or which shall be made in pursuance thereof, that is, constitutional laws that are truly legal under our U.S. Constitution, and all treaties made or which shall be made under the authority of the United States are and shall be the supreme law of the state, that is, of the state of Maryland, and the judges of this state and all the people of this state are and shall be bound thereby, anything in the Constitution or laws of this state to the contrary notwithstanding. So we've seen already the U.S. Constitution says all persons have this protected right of due process. They cannot be executed unless they stand trial through due process. And the promise is that every legislator and the governor of Maryland swear that they're going to abide by that supreme law of the land here in the state of Maryland. Now let's also look at the Maryland Declaration of Rights, what it's essentially created by the state legislature cannot contravene the supreme law of the land, the U.S. Constitution. Because if it does contravene the supreme law of the land, it cannot be law. Now, all legitimate law then must be in accordance with the Constitution. Otherwise, it is not law. So let's consider what a legislator should do in application of the oath that they have made before Almighty God. That oath requires them to determine the constitutionality of any supposed law and declare unconstitutional statutes such as those which would not protect the God-given right to life. Those such statutes they are to declare to be no law at all. And this is what would be accomplished by passing this abolition of abortion bill here in Maryland, saying all of that has been written by the state legislature that claims that a baby can be murdered with no due process of law is not law at all. And so our founders in the Declaration of Independence clearly recognized that the king had created all kinds of laws that were in violation of the English Constitution. They gave these laws a label. In the Declaration of Independence, they called them pretended legislation. Yes, they were ink spilled on a piece of paper, but they were not actual legislation. So-called law, which is violative of either the U.S. or Maryland Constitution, is not law at all. So we need to ask the question of due process. This involves the accused standing trial, witnesses being brought in, and a jury of one's peers making a determination of guilt or innocence before they can be deprived of life. And clearly, this does not happen and is never afforded any human being in the womb here in Maryland. Now let's look also at Maryland's protection in the Declaration of Rights, Article 24, that no man ought, and by man it's not referencing only the male part of humanity, all human beings, we might say, no man ought to be deprived of his life, liberty, or property, but by the judgment of his peers or by the law of the land. So, in a sense, a repeat of what the U.S. Constitution says both in the Fifth Amendment, 14th Amendment, here we have it in Maryland's Declaration of Rights, Article 24. Clearly, you cannot be deprived of life without due process of law. And the Declaration of Independence speaks to this as well. The purpose of human civil government is to secure God-given rights. And so when we ask, what are these rights and where do they come from? The Declaration of Independence clearly says this: we hold these truths to be self-evident, that all men are created equal and that they're endowed by their Creator with certain unalienable rights, that among these are life. And I'll pause right there because that's the first of our God-given rights. And then it goes on to say that to secure these rights, the right to life, governments are instituted among men. Now, rights come from our Creator. They're bequeathed at the moment it says we are created. That's not the moment of our birth. That's 9 months, generally 9 months after we were created. It's the moment of our conception that the Declaration of Independence is referring to. The time of our birth may be 9 months later. But having rights from the moment of conception, the Declaration of Independence states unequivocally that governments are instituted among men to secure these rights, that right to life that God has given from the moment of conception. So the Declaration proceeds to declare that this right to life, which is the first right because it makes perfect sense. You cannot enjoy any of your other God-given rights if you don't have the right to life and if that is not secured. Now, some will argue and say, wait a minute, David, the Declaration of Independence, it's a nice political piece. It has no legal authority in our land and no actual power legally. Well, that's an easy argument to defeat by just going down the street. You probably all came down Rao Boulevard. You probably all came by this building not knowing that the Maryland Law Library is there. And if you go to the Maryland Law Library and you go in and ask for the U.S. Code, that is the codification of all the laws in the United States, and prepared by the Office of Law Revision Council of the United States House of Representatives. And they say that This document, the U.S. Code, is the consolidation and codification by subject matter of the general and permanent laws of the United States. And if you pull down Volume 1 of the U.S. Code from the shelf, you'll find that the table of contents after that, the very first section of the U.S. Code is called the Organic Laws of the United States. And you pull that down, Volume 1 and the Organic Law, and can you guess what is the very first document in the Organic Law of the United States? It's the Declaration of Independence. It is law. Now, people will argue with you, and you say, please go down to the law library and you can see for yourself that it is law. It's the very first document. And we ask, well, what does it mean when it says organic law? Black's Law Dictionary defines organic law as the fundamental law or constitution of a state or nation, written or unwritten, the law or system of laws or principles which defines and establishes the organization of its government. So it's foundational, absolutely foundational, and therefore what it says needs to be considered. The Declaration of Independence is the organic law, and no one should persuade you otherwise. Now, we need to understand that what the Declaration of Independence is proposing and establishing is what we call the American view of law and government. First point, Declaration of Independence says there is a creator God, and it's the God of the Bible. The second is that our rights come from Him alone. And the third, that the sole purpose of human civil government is to secure and protect those God-given rights. And so the first and preeminent of those rights we know is the right to life. And so the abolition of abortion in Maryland is perfectly constitutional. In fact, I would argue it is the duty of those who swear an oath that oath requires them to pass such a bill, because anything other than that is a violation of their oath of office. Thank you.
Thank you so much, David.